As we arrive at our third session, we turn our attention to what is perhaps the most closely scrutinized stage of every arbitral proceeding, the judicial review of an arbitral award. Our ancient wisdom reminds us, Nyayo dharmasya moolamam. Justice is the very foundation of law. An arbitral award is intended to bring dispute to a close. Yet, every legal system must also preserve the sanctity of justice by providing a careful, calibrated avenue for the judicial review. Section 34 and 37 of Arbitration and Conciliation Act embody this delicate balance. They are not invitation to reopen the merits of an award. Rather, they serve as narrow constitutional safeguards, ensuring that while arbitral autonomy is respected, fairness and legality are never compromised. Where then should the line be drawn between intervention and restraint? How do our courts preserve the finality of arbitral awards while upholding the rule of law? These are questions of enduring significance, and they form the heart of our next session. Section 34 and Section 37, Navigating the Review of Arbitral Awards. To preside over this important deliberation, we are deeply privileged to have with us Honorable Justice Shri G.S. Kulkarni, Judge of Bombay High Court. There are members of legal fraternity whose careers are distinguished by the case they argue. There are members of legal fraternity whose careers are distinguished by the case they argue. There are others whose contribution lies in shaping the manner in which the law responds to the realities of societies. Honorable Justice G.S. Kulkarni belongs to that distinguished tradition. Justice Kulkarni needs no introduction. A highly respected judge of Bombay High Court, he has over 3 decades of distinguished experience in legal profession. Enrolled as an advocate in 1992, he practiced extensively in constitutional, administrative, company, and public law, and served as a special counsel for Government of India, representing several leading public authorities, institutions. Elevated to Bombay High Court in 2014 and appointed as permanent judge in 2016, Justice Kulkarni is widely admired for his erudition, judicial wisdom, and significant contribution to Indian jurisprudence. It is this rare combination of judicial in-depth and pragmatic wisdom that has earned his lordship the highest regard in the legal fraternity. We are truly honored by the grace of Lordship Kulkarni's gracious presence. With him, it is my privilege to introduce to you our distinguished speaker, Shri Atul Damle. Shri Damle, a senior advocate, among the finest tradition of bar is the ability to combine intellectual rigor with persuasive advocacy. Shri Damle exemplifies that tradition with remarkable distinction. He is a distinguished legal practitioner with over 32 years of experience before Bombay High Court. He was designated as a senior advocate by Bombay High Court in 2014 in recognition of his outstanding contribution to the legal profession. With a vast and diverse practice, Shri Damle regularly appears on both original and appellate side of Bombay High Court, handling a wide spectrum of civil and criminal matter. Over the course of his career, he has represented numerous corporations, banks, states, earning a reputation for his exceptional advocacy and legal acumen. May I call upon you to kindly invite the chair and set the motion by a big round of applause. This afternoon, the panel will guide us through the nuanced jurisprudence of Section 34 and 37, examining how court preserves the delicate equilibrium between the finality of arbitral awards and the constitutional duty of judicial review. Ladies and gentlemen, may we now request Justice Kulkarni to kindly come and address the topic. Justice Kulkarni. Thank you, sir.
Very good afternoon to you all. I think by the end of the second session and a very good inaugural session, you are almost into the arbitration, I should say. Conceptually, what is the topic is required to be seen. I was just discussing with Mr. Damle that when we talk about the subject of 34, we are all aware that we are at the fag end, or rather, the end of the arbitral process, except for what may remain in regard to the enforceability of an award. Because you are testing the award by challenging the award. And challenge to the award is confined to the statutory ambit. But the whole process, I feel, has a lot of basic background which we need to note. Some of the nuances were touched upon by both their lordships, the Honorable Acting Chief Justice, as also by Justice Gadkari and by Justice Suman Sham. The need for the parties to adopt this particular mechanism of alternate dispute resolution when they agree to this particular mode of dispute resolution by this particularly private method, I would say, a method outside the court and which is fully voluntary. Nobody has forced the party. Whether it would give the desired result and whether that result would be a result which would be borne out by the facts, by the case with which the party has gone to arbitration, are all matters of consideration. It should be effective. Principles of party autonomy, which are very paramount as discussed in the earlier sessions, would be taken into consideration the right up to the fag end of the arbitral process, that is even in the 34 proceedings. Sometimes thinking judicially, because now as judges and having come from the bar, we have changed our hat. I was wearing your hat for almost 21 years at the bar. And then what is the repercussion when you change the hat? That also I have gone through. The issue which comes to one's mind and which was reflected by Justice Suman Sham, and I have been speaking on this, Mr. Mehta is here at the IMC, that are we really out or completely beyond the purview of what was said by Justice Desai in Guru Nanak when Justice Suman Shah mentioned? He mentioned that it was a very critical comment made by Justice Desai in the Guru Nanak's case. But what was the comment is most important. Now, how many of you, please raise your hand, you know the actual comment of Justice Desai? Then I must tell you what was his comment. Now please see, and it would have relevance at the end of it, which you would agree with me. When Justice Desai said that this is something which has really bothered the legal fraternity. The enormous amount of time consumed, where people would really laugh at the system, where the legal philosophers would weep at the way in which the whole arbitral proceedings are conducted, and ultimately an endless exercise, which was the 1940 regime. But when I am confronted with the topic today, I always have a question in my mind that have we really changed? And why do I say that? It has a relevance to the second hat which I am wearing. Because even today, we argue or we consider Section 34 proceedings as if it is a first appeal. You see the grounds. Now, I am going to speak little conceptually because I have my all very young dear friends at the bar over here. The seniors need not be told anything because they are already aware, they argue every day. But what should be the approach of the junior members of the bar? When a client comes to you saying that this is an arbitral award I have, my client says that it is not a correct award and I need to challenge the award. The first and foremost thing which we need to bear in mind as lawyers at the bar as to what are the parameters of challenge. I asked a young friend that you have got an award, how do you want to propose? He said, sir, I would read the award and I would say that the arbitrator has erred. And it's not a first appeal. You can't have that approach. Arbitral law, we have such a small act. But the kind of development on arbitration law which has actually gone into with the several judgments delivered by the courts is what is really important. You may read something in the plain language of the statute, but there may be a different interpretation in a judgment. And if you are not aware about it, your ground is completely knocked out. So, my little advice to the young members would be that please see what is all this case law, what are the contours of challenge which are permissible, and although very technical now, which we'll discuss. Unless we apply ourselves to this law of precedents on all these issues as to what is the position in law in several judgments, it would not be possible for us to go out of our mindset that it is only a mere challenge on merits of the award, which is not really the scene, as the Act also would show it to you on plain reading of the provisions of Section 34. Another small background, and as also pointed out, first, please consider that this is nothing new. This whole idea of jurisprudence has taken a new dimension, I would say. It is not new to our jurisprudence. Arbitration is said to be as old as civilization. Example, the first arbitration they say was conducted by King Solomon. How many years before Christ? We don't know. Two ladies were fighting for a child. There were two children born on the same day. One child passed away. One woman, she stole the child of the other woman, and both of them started quarreling. The matter reached King Solomon, and he made them sit. He heard them. When he heard them, they say it was principles of natural justice. Then he said, what do you want to say? He said, both of you are at loggerheads. You are not resolving this. Now I need to pass my judgment. He said, you cut the child into two pieces. The moment this was said, The real mother said, please give the child to the other lady. And immediately King Solomon said that she is the real mother, she wants to save the child. The other lady was completely silent on it. That was said to be the first arbitration. This is what some jurisprudence says. So it is not something new that this method of resolution of disputes. The only thing is that the character of resolution has changed. So please conceptually see. There is nothing great about it. Or as one of our learned brothers, Justice Shri would say, this is no rocket science. This is no rocket science. It is a matter as it comes to you, a plaintiff, a defendant outside the court. And how you are going to apply yourself because they have chosen a private forum. Technicalities in the challenge are very limited. I would say a first appeal or a second appeal which you argue as members of the appellate side sometimes are more rigorous. Arbitration is easy. Why arbitration is easy? Because section 34 has culled out the grounds that these are the limited grounds on which you can challenge the award. Which are those basic grounds? Something which has been decided by the arbitrator beyond the contract. It is extraneous to the dispute. There is a breach of principles of natural justice. You had no notice of arbitration, there was no service before the arbitrator. These are grounds you argue every day in the court. Party was incapacitated to enter into an arbitration agreement. No notice of arbitration. Every day you argue this. What is so big about it and great about it? Problem comes only with a interpretative exercise. And which is that interpretative exercise? Of some technical notions which have been put into the provisions of section 34. And that's the heart. I would say that is the issue which is actually an issue which is part of the operation theatre and the surgery which is going to be undertaken on the award. And what is that? Public policy. Fundamental public policy of Indian law. These are the things which possibly, would cause you some anxiety as to whether this particular award can be fit into these slots so as to challenge the award. We'll discuss it. It's also very easy, nothing to be worried about. Now, how this concept of public policy comes in? Now, always I have wondered, and Mr. Mehta again would bear with me, that some of the concepts which are actually concepts which possibly are relevant insofar as the international commercial arbitration is concerned, which is part 2 of the Arbitration Conciliation Act, as you have seen, actually are brought in the parameters of what would be applicable, as we say, to the domestic awards. Go to the old regime of the 1940 Act. Section 30 did not have all these different grounds of challenge on public policy, what is fundamental policy of Indian law, etc. Where do you get all these things? Therefore, the background. The background is that this concept has actually evolved from what was the international scenario on arbitration, which in the context of public policy. And this is most important issue to discuss on fundamental policy of Indian law and public policy, because there are large number of judgments, a lot of jurisprudence which is laid down. Now, 1940 Act never had this particular issue, that a award can be set aside on the ground of public policy, etc. No. Because it was a basically act meant for domestic arbitration, where the award would be recognized only after it becomes decree of the court. And therefore all challenges were permissible. Sometime in 1990s, the early 90s, and to be more accurate, 1991, 92, things really opened up for our country. And it was thought, you will find all this discussion in the 246 report of the Law Commission, that our arbitration law, and as very seriously commented in 1981 in Guru Nanak, so about 10 years down the line, our arbitration law is required to be brought at par with the international standards. What are the international standards? In 1958, the New York Convention was the one which occupied the field. Now, New York Convention, insofar as public policy is concerned, is preceded by the Geneva Protocol of 1927. And the Geneva Convention, immediately thereafter in 1927, 32, subject to correction, just see, it's about 2-3 years. Now, public policy is something which came from the common law principles. Now, common law, as you know, in Great Britain, in United Kingdom, is a law which has evolved for years together. And there are uncodified principles which are acceptable as societal norms. So the English court said that if we have a particular settled legal pattern or legal concept, which we feel it to be part of the public policy, we would not recognize in our country something which is contrary to this. We have to respect all these principles which have now assumed the position as if it is the settled principle of law. Because Britain has no written constitution. It has that time it had very few codified laws, and therefore the common law principles were all principles which were gathered from time to time and developed by the society itself. So whatever is not acceptable to a particular given set of legal standards which were fixed was called to be something of public policy of the country, of the state. So when all these thoughts went on as to what would be the course of action, assuming that there is some arbitration and there is an award, and the award may possibly be contrary to our local laws, assuming the English Contract Act, and some award is delivered which completely goes contrary to the provisions of the English Contract Act. It would be offending the statutory provisions. Ultimately, it would not be a good award. That was the notion. But that came to be recognized in these Geneva Protocols. And it is with the liberalization and the growth in commerce in 1996, it was the Law Commission thought that we need to bring at par this law in a wholesome manner. One thing most important, 1940 regime, when it came to all these kind of international awards, there was a Foreign Award Recognition Act of 1968, 68 or 58? 68. 68. Because 1960 we adopted the New York Conventions. New York Conventions are 1958, 68 we came with the Act. So when it came to foreign awards, it was necessary for the courts to recognize the principles of public policy and fundamental policy of the Indian law. Now, why I'm saying this? That this is a concept which was little alien to the Indian arbitration law. And it was a concept which was available in the Enforcement of Foreign Awards Act 1968. Because a ground on public policy flows from Section 7. Now, all this has been considered, and in the morning, the discussion on one judgment I found was not there in this context, and which in fact pertains to our subject, which was the amplification of this doctrine of public policy in the decision of the Supreme Court in Renu Sagar. Renu Sagar today is the foundation. I would request all my dear friends over here that if you have not read Renu Sagar, you are missing something. You must read. It is such a wonderful judgment of Justice Agrawal, putting an end to a dispute and laying down as to how this concept of public policy would be required to be read in the context of the enforcement of foreign awards, and which is now recognized in 1996 Act in Section 34. Coming back, Renu Sagar is a decision of 1994. And that decision is recognized to be laying down the correct position in law insofar as 34 is concerned, which we will discuss now. Apart from these normal grounds of challenge, which I just narrated, which is Section 2 on natural justice, no notice, beyond the scope of arbitration, unreasonable, etc., etc. I am going to touch only on these two aspects now, after having given this particular background. I also forgot to tell you at the outset that we have the second topic, which is Section 37, which for convenience we have parameters would be almost the same, but Mr. Atul Damle, learned senior advocate, would be throwing light on that subject. Now coming back to our subject. I hope that all of you have the Bare Acts with you. Yes. Now please see how this whole issue of public policy, which I have explained to you, is in fact coming from the New York Conventions and possibly relevant earlier relevant insofar as the international arbitrations were concerned and a foreign award. Now please see 34. Come to Section 2B of Section 34, which says that an arbitral award may be set aside by the court if the court finds that the subject matter of the dispute is not capable of settlement by arbitration under the law for the time being in force, which is the Booz-Allen principle, and the arbitral award is in conflict with the public policy of India. So this is how these terms are set into motion. Now, public policy as a concept itself, and I must very candidly say, has been a matter of lot of confusion. And why it has been a matter of lot of confusion? Because eminent jurist, and for example, I would say Lord Donaldson in National Oil Company, he said that it can never be exhaustively defined. Lord Denning said that it is difficult to define public policy. It is an unruly horse on a run, which was also recognized by the Supreme Court in Central India Water Transport. But Lord Denning says in Football Association that with a good man in saddle, it can be kept under control. It can jump over obstacles. So this is how conceptually it was thought about. Then very interesting comment came in Richardson versus Mellish by Lord Barrow. And he said, and I think it is true even today, that the ground of public policy when you challenge the award is never argued except when all the other points fail. This is what he said. That you have no other ground, you argue on public policy because your client wants the award to be challenged. So this was the background on which, now please see, 1994 I pointed out to you. When the Supreme Court for the first time settled the dispute. Now Renu Sagar was a very interesting case, and I said that you must read the judgment. Whenever you have time, it is a very lengthy judgment. But that would completely clear all your doubts as to what is this whole concept of public policy. Now Renu Sagar in 1964, and this is something which you will also wonder after some time. 1964 there was a contract with General Electric for supply of electrical equipments for setting up a power plant in India. There was a dispute, there was an arbitration agreement. It was a foreign seated arbitration, a ICC arbitration. And the dispute was in regard to payment of interest, which was required to be made by Renu Sagar to General Electric. That is how the proceedings started. And mind you, there were about 10 to 15 proceedings which came from our High Court itself. And with a landmark judgment of Justice M.L. Pense, as his Lordship then was deciding the litigation on the award itself under the old Act and possibly under the Foreign Enforcement of Foreign Awards Act. It is in such context, after 30 years of commencement of the arbitration, dispute is of the contract is of 1964, dispute arose sometime in 1970 and early 80s, and it was finally decided in 1994 just before the Arbitration Conciliation Act came, wherein this doctrine of public policy which we discussed was ultimately amplified. It was made clear that public policy is required to be construed very narrowly in the context of the enforcement of foreign award. So a very narrow. Now what was the issue? Issue was that the Government of India withdrew the benefit of exemption of the interest of tax on the interest component, and that led to the entire dispute. Now once the Government of India takes steps and prejudices one of the parties, now when you start with the contract, you have a particular legal position which was operating, but by some actions on the part of the government which is in the change in the fiscal policies, etc., if it has repercussions on the contract, what would be the situation is what Renu Sagar is. For G Electric, which was a foreign party, an American party, It never contemplated that as to what is to happen here in India in regard to its, on the domestic law front. Whatever powers under the Income Tax Act, the central government would exercise and come with notifications, whether particular thing is taxable today, it is exempted tomorrow, or it was exempted earlier and then taxable, etc. How does it matter insofar as the dispute is concerned? And this is what is public policy. The Supreme Court said that all these are domestic issues. A foreign award can never be bad merely because it is offending a domestic law. And what was the law? The Income Tax Act. Applicable in relation to a agreement between a foreign party and an Indian party. How it should be affected. And that too affecting an award which is a ICC award. So this was the contour of the consideration. Similar view was taken in subsequent several judgments which we will discuss. But the basic principles in a very learned judgment of Justice Agrawal have been coined as to it would not matter. Because all these are issues the Supreme Court has observed are in the domain of private international law. And when it is a issue, when we say private international law, it is a doctrine of conflict of laws. So these are all issues of conflict of laws because you have one law, that is the Indian law on one hand, you have the foreign law on the other hand, and the arbitration is the independent arbitration. So these are not matters which are going to be available. Same view was taken in Lal Mahal by the Supreme Court, in Vijay Kariya, when it came to enforcement of the international awards, the foreign arbitral awards. As discussed in the morning session, some little, as Justice Suman Cham would say, flip-flop, but some disturbance happened because in ONGC versus SAW Pipes, which was in 2003, which is about 9 years after Renu Sagar. Renu Sagar was a 3 judges bench decision, whereas SAW Pipes was a 2 judges bench decision. It expanded the applicability of this doctrine by giving a very wide interpretation, by saying that one more ground is required to be added, and that is the ground of patent illegality, which was for the first time introduced. There was a lot of criticism on this judgment, as already discussed in the previous sessions, that this would entail review of the award on merits, which is not permissible. Because as students of law, we know that the arbitral tribunal is the expert with which its expertise, it is for the arbitral tribunal, it is in the domain of the arbitral tribunal to evaluate the evidence, come to a particular finding on the basis of the materials. And if it is beyond the evidence or beyond materials on record or beyond the contract, then certainly the award is required to be interfered, settled principle. On the face of it, once you say patent, it should be on the face of it. Like a claim is made, say for 50,000 rupees, and the award is for 2 lakhs of rupees. I mean, on the face of it, it has to go. Now, what kind of adjudication? Or the contract pertains to, say, goods X, however, the award is in respect of goods Y. It has to go. So these are the kind of instances. So, while reviewing the merits of the ONGC case, the court had failed to consider some of the significant things which were actually foreign, which were foreign to the award. Like, for example, something happens in UK and there is a strike. That was one of the issues in SAW Pipes. There was a labor strike in UK, and therefore, the obligations could not be discharged. Now, how is it relevant? Now, would that entail that the Indian court would go into the causes of the the strike, the UK strike, and adjudicate on that, oh, no, you are justified. That's not something which can be taken into consideration. So there was a lot of, and this position was then commented, in fact followed in Western JACO, and in 2015 for the first time some corrective measure was taken in the decision of Justice Nariman of the Supreme Court in Associate Builders versus Delhi Development Authority, which was also discussed in 2015, where the whole concept of public policy was again streamlined and accepted to say that it should be the narrow interpretation which needs to be accepted. However, there were some little issues which had, or loose ends I would say, which remained in Associate Builders, which were later on rectified in Sangyong. Now Sangyong was a case of 2019 and which I would say that it holds the field till date, where the Renu Sagar understanding of the doctrine of public policy was accepted by the Supreme Court to be the correct position in law. And therefore, when we come to that particular issue on as to whether the award is contrary to public policy, we don't have to look anywhere else but to the Renu Sagar principles. So two fundamental decisions. First is Renu Sagar, the second is Sangyong, and followed in several recent decisions, which a list I'll give it to you. Now I am touching the other aspect of the matter. Fundamental policy of Indian law. Now two things. Again come back to the section now. This is little technical, therefore I am inviting your attention. Now please see the provision. Ah, 34, sorry. Sorry, I just so we have seen public policy in B. Now come little below. For the making of the award was induced or affected by fraud or corruption, or was in violation of section 75 or section 81, and then below it, the award is in contravention with the fundamental policy of Indian law, and it is in conflict with the basic notions of morality and justice. These are the two other grounds with which you would be confronted, that if you don't have any other grounds, whether we can fit our case into this. Now when we talk about this, as to what is the fundamental policy of Indian law? Can anybody say that what would be the fundamental policy of Indian law when you are confronted with an award? Any answer? Anyway, I'll just tell you. So it has been construed in decisions that fundamental policy of Indian law would be violation of statutes, principles of natural justice, rules of fair procedure, and interest of justice or morality would be fraud or corruption. So these are the points on which you will have to examine the award as to whether there is any violation when we are talking about domestic awards now. Violation of statutes, principles of natural justice is within the ambit, fair procedure, no notice before the arbitral tribunal, and it is in the interest of justice or morality. Or for example, a highly objectionable award on something which is completely prohibited by law is rendered. Of course, it would be contrary to the basic notions of morality and justice. Significant amendment came to be incorporated in section 2 capital A in 2015, where it says that the arbitral award arising out of arbitrations other than international arbitrations may also be set aside by the court if the court finds that the award is vitiated by patent illegality on the face of it, appearing on the face of the award. And when you are called upon to determine the issue of patent illegality, it would not mean the review or the revisiting of the award on merits of the award. Because we are all aware that when the 34, this is where the mistake happens, that when the 34 courts actually dwell on the award, it is not like a first appeal. These are summary proceedings. MK Global, the Supreme Court has said that these are summary proceedings. That you have to just see whether all these ingredients to challenge the award are present. But the entire scenario in the court, please go to any 34 court and sit and please see how the lawyers want to intend to argue this 34 petition. They would start as if it is a final argument before the arbitrator. They'll start with basic. Speaking for myself, when I was sitting as a 34 judge for quite some time, I mean, we learn with the bar, and always I have inculcated that approach that mutually we are on the same page as the law would require. That you can't be, it can't be that a lawyer is on a different page in understanding the whole contours of what the court is going to decide. Then there is a mismatch. And once there is a mismatch in the court, I need not tell you what happens. So therefore, the first question any court would ask you is how the award is bad, which is the provision under 34 is attracted, whether any of these 4-5 principles are attracted, or if they are not attracted, whether it is bad on the ground of public policy. If it is bad on the ground of public policy, how it is bad on public policy, whether it is bad on fundamental policy of Indian law, how it is bad on fundamental policy of Indian law. That is the only contour to which you may have a reply or you may not have a reply. And therefore, being summary proceedings, the expectation of the parties would be that the award is, there is no need for this lot of pendency of these 34 petitions to remain in big compilations, volumes, written submissions and propositions, etc., etc. No need. Once the facts are there, you would have to confine yourself with the issue of law, as we argue in a second appeal, or we argue in a 260A appeal under the Income Tax Act. That this is what we feel is objectionable, why it is objectionable. If you are getting the whole crux of it on this, I don't think that you have at all any worry. You can sail through in the matter and there is absolutely no problem. There is no need to worry at all on all this. So 34, I feel with whatever the interpretative exercise which has been undertaken for so long, ought not to be any challenge insofar as our learned members of the bar are concerned. Things are much simplified. The law is now well settled. Principles are well settled. And I don't think, except for whatever happens before the arbitral tribunal, and which has some bearing and relevance when we consider these 4-5 grounds right at the beginning of section 2, apart from the fundamental policy, etc., it ought not to be a problem. Now, difficulty is twofold. And it is a conceptual difficulty. Ad hoc arbitrations, as we said, it is very difficult, though Mr. Mehta may feel that it is high time that, we dispense with the whole mechanism and slowly we shift to institutional arbitration as what is expected under the 2019 regime, which is not fully notified. But for a system like ours, and which I have been speaking, and this is little out of context, ad hoc arbitrations cannot be replaced by institutional arbitration wholesomely. There has to be a window kept open where our learned members of the bar, the retired district court judges, the retired high court judges, they are doing wonderful job in respect of these arbitrations, which may not be very high stake arbitrations. I ask a question to Mr. Mehta. Whether in every possible arbitration, now I had a matter before me, a section 11, where a small contract of hiring of a crane for a period of 23 days, there was an arbitration agreement. The dispute between the parties was only 13 lakhs of rupees. Can such matter go to institutional arbitration? If it is going, well, 13 lakhs of rupees which can be settled, and it was settled in one go. That was the next. So there are categories, and I always give an example of a Mama Bhanja, where the Mama Bhanja came together and started a jewelry firm. Mr. Mandavkar is aware about it. That example I gave. And they had a dispute, and there was an arbitration clause in the agreement. And when the matter came before the court for appointment of an arbitrator, they said, sir, as far as inventory is concerned, we had an inventory in the jeweler shop of about 3,50,000 jewelry, some earrings and some necklaces, etc., all that we have sorted out. There is a dispute which is on the accounts. So I said, how much is it a very big amount? He said, no, it is only 3.5 lakhs. Still matter came to the High Court. See, this is the arbitration scene. You will not find this arbitration scene elsewhere in any part of the world, because there it is mostly institutionalized. However, our legacy in arbitration is far, far richer, I would say. It is more prominent, richer, and very deeply embedded in our system when we are talking about ADR. People are already aware about it. And not to avoid courts, but for ease of business, they have already adopted themselves to the alternate dispute resolution of this nature to go to arbitration. So, it is our duty as judges and lawyers to see that whatever is voluntarily decided by the parties, it is made effective. And not, put spokes. No, we'll challenge this award. It is like that famous story at the bar, that one lawyer was approached by a client and he said that there is nothing in your case. Nothing can be done. He said, sir, why you are so negative? Something can be done. He said, no, I am not going to do this. So he went to another lawyer. He said, there is everything in the matter, I will do it. So he said, see, I went to the other person and he said that, no, sir, please do it. He went to the court. And ultimately the matter failed, because what was the first advice was the correct advice. He said, see, you have understood the matter, I have understood, but the judges have not understood the matter. So we'll go to double bench. So double bench also again the same thing. It's a very famous story at the bar, everybody of you know. So double bench also dismissed it, there is nothing in the matter. He said, see, you have understood, but these two Johnnies who are sitting there, they don't understand. This is how, things matter when people are not aware. You go to a doctor, he tells you that yes, you will have to take this medicine, you close your eyes and take the medicine. You would not confront him. This is where our role as lawyers and judges becomes very important. When we talk of arbitration, And when we talk about the whole arbitral process, which is very rigorous, it is like a full-fledged trial before except with the strict rules of evidence not being applied or not applicable. When the award comes, always our duty to the profession should be that we guide the client properly and that the fruits of the arbitration should come to the parties the way the arbitration mechanism has been couched out. With these little words, I would not take more time. Thank you so much for the patient hearing.
Thank you so much, Kulkarni sir. May I now request Atul Damle sir to please.
Thank you, my Lord Justice Kulkarni, for your overview on Section 34. That left with me with a little time on Section 37, because the scope of Section 37 is much narrower than Section 34. Section 37 provides for statutory appeals. It's not that in a normal scenario, in a civil dispute or a civil courts, we have a right of appeal against every order which is being passed. But under the Arbitration Act, the whole purpose is to minimize the court's interference or minimize the litigation. The Section 37 has been introduced here. Because only few orders are appealable under Section 37. Section 37(1) is in respect of the orders passed by the courts which are appealable. The first instance which has been given is orders passed under Section 8. Section 8 is, as in the earlier session, you have been told about Section 8, where the parties have raised, if any proceedings have been initiated in any judicial forum, the objection has been raised that the dispute pertains to arbitration agreement. In such situation, the option open with the court is to refer the dispute to the arbitration and not go ahead with them on the merits of the matter. If a court refuses to make a reference, then only the order becomes appealable under Section 37. If a court comes to a conclusion that matter has to be referred to the arbitration, there is no appeal provided under Section 37, and the parties will have to go to the arbitrator and resolve their dispute as per the arbitration mechanism. That one. Second are the orders which are passed under Section 9. Section 9 orders are something which are similar to Order 39, which we normally know, where we file Exhibit 5 applications or interim applications in the civil courts. So those applications, if Section 9 has been filed, either it is granted or refused. Both orders are appealable under Section 37. That's the second. And third is obviously once the arbitration award comes in, a party approaches 34 court. And once a 34 court decides either to accept the award or set aside the award, both orders are appealable under Section 37. So this is in respect of the orders passed by the court where the appeals have been provided for. There is a subsection 2 is in respect of the orders passed by the arbitral tribunal. The first is order passed under Section 16. As you all are aware that Section 16 authorizes the arbitrator to decide on his own jurisdiction. So if an arbitrator decides on his own jurisdiction and come to a conclusion that it lacks a jurisdiction or has exceeded the scope of arbitration, only in such eventuality the appeal is maintainable under Section 37(2). If an arbitral tribunal come to a conclusion that it has a jurisdiction, then the appeal will not be entertained, will not be able to be filed before any court under Section 37 because appeal is barred under that. Then the second type of the orders which can be appealed is where the Section 17 orders are passed by the arbitral tribunal. Section 17 is again something akin to Section 9, where the interim measures can be passed by the arbitral tribunal. In case of parties choosing not to go to Section 9 before the before the court, but chooses to go and approach the arbitrator when the arbitral tribunal is constituted to apply for Section 17 application. Section 17, again the same principles as we know under Section Order 39 are come into picture. And in such situation, either Section 17, the arbitral tribunal grants or refuses. Both orders are made appealable under Section 37 before the competent court. And on this, there's one more aspect I must point out, that Section 17, subsection 5, enumerates that the orders passed by the arbitral tribunal are akin to the orders passed by the civil courts. This has been provided with a view to make a binding effect on the orders which has been passed by the arbitral tribunals. If the arbitral tribunal passes an order of injunction or any protective measure or any order which is protecting the subject matter of arbitration, then in such cases those orders needs to be enforced. And that's the reason Section 17(5), subsection 5 provides that the orders passed by the arbitral tribunal will have a same effect as of an order passed by the civil court. And in some cases it has been held by Apex Court, something like Alka Chandewar, then Amazon and ArcelorMittal, that the orders passed by the arbitral tribunal can be, if there is a breach, the contempt proceedings can be initiated, and even order in the striking of defense and other things also can be taken up before the appropriate quorum. Then Section 37(3) provides that there is no second appeal which is maintainable under the Act. So these are the provisions under Section 37 which contemplates appeal only in a limited scenario. There is no full-fledged appeals like what we know under the Civil Procedure Code, where every order can be appealable, every order can be revisable, or if there is no remedy, then you come under Article 226, 227 before the court and challenge. The whole idea is to curtail the interference of the court in the arbitration proceedings, and the award needs to attain the finality. That's how Section 37 has been worded with. Then, as you all know, that the appeal is always a creation of a statute. So any order which is not appealable made under Section 37, there is no appeal can be filed before any forum. Then one more aspect is there, that under 37, Section 9 order has been passed by some court prior to coming before the arbitrator if the Section 9 order has been passed. As we know, Section 9 can be in two parts. One is the ad interim order, and there can be a final order on Section 9. The judgment in case of ArcelorMittal make it clear that ad interim orders under Section 9 are again not appealable. So you have to wait till final order which has been passed under Section 37, under Section 9, and then only you can approach the court. Then the second aspect is where these appeals lie, because we'll have to see the appeal provision where the appeal lies. For that, we'll have to see Section 2, subsection E, which defines the court. The court is the principal civil court of original jurisdiction. So if a dispute is in between the parties, which is within the jurisdiction of a civil court outside Mumbai, then in such cases, a district court will be the principal district court where the Section 9 application can be filed, where ultimately Section 34 also can be filed once the award comes in. And if it is within the jurisdiction of a city of Mumbai, then the principal district court becomes the original side where the appeals can be filed, where if a Section 9 order has been passed by a learned single judge, then appeal will lie before the division bench. Similarly, if an arbitrator passes an award within the jurisdiction of a city of Mumbai, then 34 petition will go to the original side of our Bombay High Court, and the appeal against that will go to the division bench. So this is the mechanism which has been provided for the forum and the challenge. Then second aspect is what will be the limitation. As we all know, as in Section 34, there is a limitation which has been prescribed, 3 months plus 1 more month, 30 days extension can be within that period, that is 120 days you have to file appeal. Section 5 of a Limitation Act is not made specifically applicable to Section 34. So there is no question of you going and filing an application for condonation of delay in filing Section 34. If you loses your right to file appeal within 120 days, then you loses your right to challenge the arbitration award. And only one possible saving of a limitation is Section 14 of a Limitation Act. If a party chooses to file a challenge before some forum which has no jurisdiction. In such cases, a exclusion which has been, time which has been spent in section 40, in that wrong forum, that time can be excluded. But once the 120 days are over, there is no time, there is no other way in which you can challenge the arbitral award. Similarly, for filing appeal under to challenge the orders passed by either by the court or by the tribunal, we have to go back to the Civil Procedure Code and Limitation Act, because Article 116 of a Limitation Act will come into force, where as we normally do, if it is an order which has to be appealed before the High Court, the period of 90 days is contemplated, and if it has to be to a district court or any other court, a period of 30 days is contemplated. Then again, we'll have to see what is the procedure governing Section 30, appeals under 37. The provisions are something similar to the Code of Civil Procedure, which will come into effect as if it is a normal appeal which has been heard by a normal court. Then we go to the Section 43 also provides for a limitation, and then it says, then one more aspect is earlier prior to 2015 amendment, once a Section 34 petition is filed, there used to be automatic stay. But that position has been changed by amendment in Section 36, where Section 36, 2 and 3 provides that award will remain enforceable as a decree of a court unless the appellate court grants a specific order of stay on an application made by the judgment debtor subject to such condition. So there won't be any automatic stay. A party has to make out a case under Section 37, and if a appropriate case is made out, then only a stay is granted. Then we go to the another aspect. All these provisions of a Section 37 are only are there only to minimize the court interference, the speedy disposal, and are giving a finality to the arbitral awards which has been passed. Then we'll have to see technical two aspects I would like to say is regarding the court fees. In a challenge to Section 34, either in a district court or before the High Court on the original side, Article 3A in Schedule 1 has been contemplated, whereby the court fees are also required to be paid. Similarly, if an appeal has to be filed under Section 37, challenging the order under Section 34, a similar court fees as provided under 3A of Schedule 1 is required to be paid. So all these, I will not address you more on the scope of Section 37, because scope is very limited, very narrow if you are looking at Section 34 order. As my Lord Justice Kulkarni has already explained the scope of Section 34, where the courts can interfere with the awards and what are the parameters for that. If we are looking at the Section 37 appeal, where the 34 award is being challenged, the same parameters, rather a scope becomes narrower than Section 34. So the interference becomes very less. Then one more aspect which I must point out, whether, as we all know that in any civil proceedings, if an order is not appealable, parties file either a revision or come to a writ court, invoking Article 226 or 227. In arbitration, it has been held that Section 37 is a code in itself. You cannot go beyond Section 37 and invoke any other remedy except so there is no revision which can be filed. But regarding Article 226 and 227 interference, in case of exceptional cases, the apex court in case of IIT Siemens held that in case of exceptional cases or in case of extreme case, a court can exercise the jurisdiction under Article 226 and 227 of Constitution of India. My Lord Justice Kulkarni has recently, although he has decided that issue where the parameters are laid down when Article 226, 227 can be invoked in arbitration matters. In that matter, but my Lord Justice Kulkarni has chosen to interfere in the orders which has been passed by the arbitral tribunal and interfere with this. But as in that judgment, the parameters have been laid down. When a person can go, any order which has been passed by the arbitral tribunal can be challenged in Article 226, 227. Very limited scope as has been dealt by Justice Kulkarni.
Party autonomy.
So
Party autonomy.
Yes, principle of party autonomy has been invoked. So with this, I will try to sum up to say that Section 37 provides for a limited statutory right of appeal. No appeal lies except as expressly provided in the Act. Appellate court exercise supervisory powers and not a appellate jurisdiction over the arbitral tribunal's award. Then scope of section 37 is closely linked and not wider to section 34 as narrated by Justice Kulkarni. Then reappreciation of evidence, assessment of contractual interpretation, all other things are not available even under section 37. So this is the scope of section 37. Thank you very much.
Thank you so much, Atul Damle, sir.
छान सगळं नाही नाही अरे काय एवढा वास्ट आहे
I understand that we are standing between you and your lunch, so let me conclude this session. As this engaged session draws to a close, may I, on behalf of Advocates Association of Western India, convey our sincere gratitude to our distinguished chair, Honorable Shri Justice Kulkarni, and our esteemed speaker, Atul Damle, sir, for their invaluable insights and thought-provoking deliberation. Your guidance has helped us appreciate that judicial review under Section 34 and 37 is not an avenue of rehearsing disputes, but a careful structure mechanism that reinforces confidence in arbitration while preserving the rule of law. We are deeply honored by your gracious presence and generous contribution to this workshop. May I request AVI members, Shri Prashant Relekar and Gurudas Godwatkar, to kindly come and felicitate the chair and the co-speaker. May I request the volunteers to please bring in the memento and the garland. We are really grateful, sir. I request, thank you so much. I request the volunteers to kindly assist the dignitaries of the dais. Thank you so much, sir. My apologies, sir, but that was the thing. My apologies, sir.
Before parting, I must congratulate the AWI team of Mr. Redekar, Mr. Dande, Mr. Sabrad in taking this initiative, and thanks to all the inspiration from Mr. Mehta of the IMC. He has been working, I was almost for 11 years I am going to IMC and delivering a lecture on every possible topic. So heartiest congratulations to you, Mr. Redekar and team, and please do keep on organizing this kind of functions so that, and conferences, so that the younger members of the bar who are actually not having that advantage as what we used to have of the seniors being there sitting in the bar room is becoming available through the medium of this conference. Thank you so much.
Thank you.